yesterday.
We'll resume the hearing. It's day 4 of Stream 8. The Meridian team. Ms. Foster, would you care to introduce yourself and your colleague?
Oh, really? She?
Yeah, I'll endeavour to do the introductions. Good morning. My name's Andrew Ferrabund. My role within Meridian Energy is to coordinate statutory advocacy in relation to renewable energy development across the nation.
I think you need to spell your surname for me.
Ferrabund, F-E-I-E.
F-E-I-E.
R-A.
R-A.
B-E-N-D.
F-E-R-E.
F-E-I-E.
So I can't even read.
It's everyone.
Handwriting. F-E-I-E-R-A-V-E.
N-D.
Okay.
Perfect. And to my right, most of you will know Christine Foster is a consultant we use extensively in relation to providing professional planning advice to us with respect to plan making and policy making. Our primary concern, I guess, with this section of the plan that we're dealing with is around plan architecture, making sure the relevant sections of the plan talk to themselves from the point of view of being clear in terms of what policy direction applies. In this case, we're reasonably happy with the architecture and the construct of a separate chapter for renewable energy development. But as Ms. Foster will explain, we do have some concerns with respect to I guess how particularly the sections of this part of the plan don't speak to that chapter. Our interest in the Wellington region is we've got 3 assets here, Mill Creek, Westland, and the Brooklyn turbine, probably everyone's most familiar with. So on that note, I think it's probably best to I think Christine's got some speaking notes here to kind of consolidate our thinking and then kind of work out a plan from there. That's happy with, the panel's happy with that.
Well, I wonder if we could cut to the chase here. I had a discussion with each of the reporting officers and asked them what the intent of the plan was, and the answer was that nothing in the coastal environment or the NFL chapter, not the objectives, not the policies, not the rules, would apply to REG. The question I have for you, the loaded question I have, if the plan said that in words of one syllable, would that solve 98% of your issues?
Yes. Yes, it would. So,
and part of the discussion I had with the reporting officers was the fact that their drafting to date didn't appear to quite say that in words of sufficiently short syllables, and they've indicated to me that they're thinking about how it might do that.
yes. Yes.
But so happy to hear your speaking notes, but let's take that as the introduction.
Oh, that's really useful. Thank you, Mr. Chairman. So, Tato, Christine Foster is my name. We've had a useful discussion just now also with the officers about that very issue. So I will, I'll hand these notes up if that's all right. It's because it's, who do I give them to? You need to be beautiful assistant, and I'm just happy to be it. I'll leave Spears with the officers.
Yep.
They essentially address exactly the point you have just made, Mr. Chairman. So just start at 1-2. I have read the supplementary statements of evidence of the 3 experts that we've heard from. I watched most of the first day, so I'm aware that you're alive to the issue. I didn't want to bore you too much with it. And I also watched, I didn't watch yesterday, I had some Environment Court conferencing that I had to attend, so it just prevented me. But so on the topic of the self-contained REG chapter, a key issue raised in Meridian's submissions and in my evidence is lack of clarity in the PDP about the extent to which the objectives and policies of the district-wide chapters have to be brought into consideration of applications for consent under the rules of the REG chapter. It is clear that the rules of the other chapters don't apply, but the issue is about the objectives and policies. Both Mr. Searle and Ms. Van Haren-Giles have clarified in their rebuttal statements and in answer to the hearing panel's questions that the intention is, as you have just stated, Mr. Chairman. They both agree, though, that it is not clearly stated, and they refer to text in the general approach section of the plan. I don't think that text either clearly states the intention. It's also somewhat hidden at the front of the PDP, and the expression generally operates as a standalone chapter, I think invites the possibility that these chapters are not entirely standalone. Meridian's submission accepted that the objectives and policies, but not the rules, of the other district-wide chapters would be applicable, and that is why its submission sought REG enabling amendments to the provisions of those other chapters. And just by way of context, I was just had our conversation with the officers just now. I explained that Meridian was involved, I was, Mr. Fairbairn was, in the draft process, talking primarily to the author of the REG chapter. The very clear vibe we got through that process was that these district-wide chapters would apply to REG. So the REG chapter would do the promoting and enabling, and the other district-wide chapters would advance the interests of the environment, and the reconciliation would be done on a case-by-case basis. And that's commonplace in other plans. And my reading of the National Planning Standards is that it doesn't direct that all REG provisions must be in the REG chapter. It doesn't prevent the other chapters from applying to REG development proposals, and many other plans do exactly that. So,
but the National Planning Standards don't direct the alternative either. They don't direct
so the matter is open. I
think. Yeah, it's an open question.
So just by way of background, so that you understand that. The officers have expressed the clear view that you've articulated to us. But having said that, Mr. Searle has recommended some additional navigation text for the introduction to the CE chapter. It picks up and abbreviates wording that Meridian suggested. Ms. Van Haren-Giles has proposed similar text for the NFL chapter. They both recommend that the matter should be deferred to hearing stream 9, REG, or to the later integration hearing. Their response to Meridian's requested amendments to the CE, NFL and PA objectives and policies is that they are not necessary, because the CE, NFL and PA objectives and policies do not apply. I understand their logic, but if this is the intention of the plan, and if this is explicitly stated in either those other district-wide chapters or the REG chapter, Meridian's concerns fall away. However, having read Mr. Searle's rebuttal statement, the position as stated in the PDP remains somewhat ambiguous in my view. And the PDP needs to be clear on this point, and the panel will appreciate the importance of that REG proposals are difficult ones to consent, even upgrading, which is the likely prospect, if you like, for Wellington. And plans need to say what they mean in the face of third parties looking for chinks. So as little squish as possible on this point would be helpful. Meridian would want to avoid a situation where it is denied an opportunity to discuss its substantive changes to the CE, NFL and PA chapters, objectives and policies now, on the understanding that the REG chapter is mutually exclusive from those other district-wide chapters, only for this position to be changed by a later recommendation to a separate hearing stream or by a separate hearing panel finding. The issue for this hearing, therefore, seems to me to be settling on the wording of clarification notes that make the council's intention clear. The issue perhaps then becomes one of process, and how and when is this clarifying text to be generated, and are any drafting instructions required to ensure the clearly stated intention is carried forward? So I'm happy to take questions on that particular part now if you want. And there were just a couple of other content matters. I haven't gone through and said we agree on this, we don't, but I've just picked out a few items where I have perhaps a subtly different view, and they relate to policy NFLP2. And in my evidence, I proposed an amendment to that policy. Ms Van Haren-Giles rejects that suggestion. Her reason is that the change is unnecessary because all REG provisions are contained in the REG chapter. But again, if that's the case, the concern falls away. But I confess that in drafting my amendment, my focus had been on REG. I accept there may be other forms of development that may also have functional or operational needs for location in a significant amenity landscape. I agree with Ms Van Haren-Giles that replacing the and with an or at the end of clause 1 is appropriate, but I had read the policy as expecting that adverse effects must be avoided, remedied or mitigated even where there is an functional or operational need. And for that reason, it may be that a version of my amended text may be appropriate, but referring to development more generally rather than only to REG. So I can take you to the particular provision and that's my evidence, but if you go back, it'll
You don't need to. We had a discussion with Mr. Lewandowski for Parkvale Road Limited on exactly that question,
right,
bouncing around different drafting. I think that the thrust of that was that they shouldn't all be alternatives, and it needs some combination of and or. That
yes,
so that, as you say, functional and operational need doesn't obviate the need
yes,
for
yeah.
effects management.
I just felt it was important to record that an acceptance that functional and operational need isn't a trump card in that sense. So that's that was yesterday. You said, Mr. Yes, I'm sorry I missed it. I was having way more fun. Policy NFLP3. In my evidence, I opposed an amendment Ms Van Haren-Giles proposes to that policy, and it was her changes to changing provide for to only allow. Since writing my evidence, I have become aware of the drafting protocol used by the Council in drafting the PDP, which equates provide for policies with permitted activities and only allow policies with restricted discretionary activities. I therefore understand her reason for the choice of language because the protocol takes a very narrow approach in assigning policy verbs in my view, but I understand the reason for it. However, my concern would fall away if the officers are right about the freestanding chapter REG. This one is NFLP4, and in my evidence I misattributed the section 42A report discussion to Mr Searle, and I should have referred to Ms Van Haren-Giles, and I apologise to you for that error. Ms Van Haren-Giles has rejected my proposed amendments to policy NFLP4, citing her view that the amendment is not necessary because the REG chapter addresses these matters. Again, if that's the case, the concern falls away. However, that avoids the point that I was making, that the proposed amendment fundamentally shifts the policy from a provide for policy to an avoid unless policy, which in my opinion is a response that may be warranted for outstanding natural features and landscapes in the coastal environment, but not for significant amenity landscapes. In my opinion, clauses 1 and 2 of policy NFLP4 already do what the NZCPS policy 15B directs, that is, the avoidance of significant adverse effects. Also, in my view, it follows that the identified landscape values that are referred to in that policy cannot be completely maintained if there are effects on those values, even if those effects are mitigated or remedied. So that's the construction of the two clauses of the policy. The second one requires maintenance, but the first one allows you to change something. So in this respect, clause 1 seems to conflict with clause 2, and it may be that clause 2 might better read and the activity otherwise maintains the identified landscape values and characteristics. Maybe issues of scope, but it was just a planning suggestion for you there. I see some conflict. Policy NFLP5. Ms Van Haren-Giles rejected my proposed amendments, again because of the rationale that the REG chapter captures everything, but it overlooks the point I was making that the absolute protection direction of clause 2 seems inappropriate and is not mandated by any higher order policy instrument. Policy NFLP5 is about outstanding natural features and landscapes outside the coastal environment. The section 6B direction is to protect from inappropriate subdivision, use and development, not to protect, absolutely. And again, there is a potential conflict between the two clauses of the policy, and the questions, can the identified values be protected? Absolutely, where the first clause permits adverse effects. So my opinion is unchanged, that clause 2 could safely be deleted without leaving any policy gap. Objective CE02. Mr. Searle has recommended a substantive amendment to this objective to the effect that it is the areas themselves and not the identified characteristics and values that are to be protected from inappropriate subdivision, use and development. I said in my evidence that given Clive Anstey had recommended inclusion of more detail describing the identified characteristics and values in Schedule 12, I didn't propose to pursue the amendment Meridian sought, which was to more explicitly refer to the characteristics and values within the mapped areas. However, the deletion Mr. Searle proposes takes the focus away from those characteristics and values onto the area itself. He had not explained the reasons for this amendment in his rebuttal. It may have been something explained in oral evidence that I haven't heard, but my view remains that the publicly notified version of Objective CE02 is appropriate. And lastly, turning to Coastal Environment Policy 10, I recommended in my evidence that this policy be deleted because it adds no meaningful guidance. Mr. Searle stated in his rebuttal statement that he has proposed amendments, but none was shown in Appendix A. I heard Mr. Searle's explanation at Monday's hearing session that he intended the amendment to list the activities from non-complying activity rule 11, which he considers to be inappropriate activities. I also heard the panel's questioning about ways of refining that wording to provide more guidance. I remain of the view that as currently worded, the policy provides no guidance on what is inappropriate and should be deleted in its entirety. Happy to answer any questions.
Thank you, Ms. Foster. I think in a process sense, I think the reporting officers have told us what the intent is, what their understanding of the intent, and I take your point that may have shifted from when you were discussing the draft plan. But you'll understand that we're only focused on this one, Absolutely. This plan. We've got quite enough problems with this plan without worrying about the previous iterations. That my reaction, given that the intent is clear, is that I don't think it warrants conferencing. Like, we've got a perfectly clear fix on what it needs to say, and the only question is whether what the revised wording that the reporting officers come up with says what we expected to say. So as I say, I'm not going to direct conferencing. We've taken on board the point. We've had a thorough discussion. We've been told that, in effect, that the reporting officers are on the case, and so we're happy to wait to see what they come up with. But I am interested in some of the logic because of your position, because of its implications for non-REG. So I'd like to discuss that with you, accepting that Meridian is now paying for you to give us advice on issues that don't affect it, but I'm sure Mr. Ferro will cope with that with due equanimity. A general question I was asking Ms. Van Haren Giles, it was actually in relation to NFLP2. About the wording of version saying any adverse effects can be mitigated in the same way. Similar provisions that say the direct, avoid, remedy, or mitigate. And my question was, is there a fundamental problem with that on the basis that anything can be mitigated? It's the extent of mitigation that counts. It's whether it's adequately mitigated or appropriately mitigated in view of the objectives. What's your view of that point?
Yes, the challenge then becomes providing enough guidance on what is appropriate, where that line falls, and the wording from the Act doesn't really help us in that respect. Doesn't tell you where along the spectrum you should fall.
But equally, as you said, as you referred, people looking for chinks in the armour of an absolute code, equally developers looking for an opportunity to say, well, I painted it, so that's enough. I've mitigated it. I'm within the policy. Does it need to at least say there is a question as to the extent?
I think you're right, which is essentially what I've just said. I don't have any suggestions for how you provide guidance on where that line falls, but I think there are two ways of coming at that, and it is a very broad direction at the moment about specific guidance.
There's in terms of NFL P5 ONLs, fortunately none of your turbines are sitting on an ONL, I think.
Yes, that's all.
Yeah, oh, is that right? Well,
So
so this is I was reading your logic. First of all, emphasising the fact that 6B is referencing inappropriate subdivision use and development. And the point I wanted to put to you was whether the Supreme Court have effectively gutted the effect of that qualification by referencing it back to the thing that needs to be protected. So in terms of what you put, what is the test of appropriateness? The Supreme Court have told us that what is appropriate is something that will protect the values of the ONL in question, so that it doesn't actually qualify it in the extent to which some of the old cases, like I'm thinking about the Environment Court's FETU decision, said that that takes you on a much broader inquiry. They've now said it's a very tight, almost circular inquiry. And so what's your reaction to that?
Well, there's some quite helpful guidance in the Supreme Court. You're talking Otago decision.
Yes, indeed.
Yes. Which goes to exactly the issue that's in clause 1, which is about how you step through understanding how to avoid, remedy, mitigate. Yeah, and I think that the concept of deliberatively considering what the values are and how you go about remedying, mitigating, avoiding is captured by that first clause, not assisted by the second.
And on that point, and maybe your argument is the same, that in the mists of time, I had shared your view and been a party to a decision on the Queenstown plan that I've worked on that premise, and then being told by the Environment Court, no, that's wrong, and that the that the overall premise should be protecting the values of an ONL. And so have you considered the appeal decisions on the Queenstown plan
No, I
in
haven't.
relation to outstanding
Not
landscapes?
in detail in preparing this.
You understand that because they told me it was wrong. I have very clear recollections of it.
I do know that feeling, sir.
Um, in relation to P6, NFL P6, you've accepted Ms. Van Haren-Giles' reasoning, and I wondered whether the recent Supreme Court decision in relation to the East-West Highway gives more comfort that there is some wriggle room in this sort of policy, that a void isn't quite as blunt an instrument as one might have thought reading King Salmon.
Yes, I think the basic architecture, I agree with Ms. Van Haren-Giles is correct. So, but I agree with you that decision is interesting in allowing the specific values and effects, very detailed analysis of that to be considered in the context of national, significant regional benefits. So yes, it was an interesting decision, not a majority one in that respect. Yes, so I read it.
What was that, sir?
I thought it wasn't a majority decision.
I
It was a majority decision.
Yes, it was.
Some contrary.
Yes, it was
A majority with contrary views. Yeah.
Majority.
They landed in the same place.
Yes, majority on one side, one judge on the other.
Yes.
One judge at the other extreme.
Yes. Yes. So interesting, I think, is the right word to describe it. But it clearly signalled that that word shouldn't be construed as an absolute end of the matter, as many people have been.
Any questions, commissioners?
I think you've asked all the hard questions.
One, actually, just on NFL P5, you're suggesting deleting the clause 2. I just wondered whether characteristics would be lost with that. Should that be moved up to clause 1? So it would be identified values and characteristics.
It's interesting, isn't it? I hadn't picked that the first clause doesn't refer to values and characteristics, but the second does. I think to be complete and in the language used elsewhere in the plan, both words are relevant. Yes.
Yeah.
Thank you.
Thank you.
Okay. I think that's us. We're good.
Thank you.
Thank you very much to you both.
Thank you.
That's all right. Okay, we'll adjourn and is Ms. Lester's attending in person too? Is she right? Okay. We'll break until we have the entire WILE team online.
You are good. I'll
Let's
just
go.
pass you back to Joe.
Thanks, Joe. Thanks. Okay, thanks, Joe. All right.
Amanda and Kirsty are online, so we're good to go. You're ready.
We'll resume the hearing since I understand the entire WILE team are now present, either in person or virtually. Ms. Dewar, are you
Good
out there?
morning. Sorry about that. New teams, old teams playing with systems.
First question, Ms. Dewar, I trust you're feeling better.
I'm getting there. Thank you very much. And thanks for receiving my submissions late. It seems as though this version of COVID has a much longer tail. So I'm still a bit brain dead. So please bear with me. But I'm getting better. Thank you.
Okay, well, we have your submissions. We've read the evidence. I've just been given a copy of Ms. O'Sullivan's summary statement, which I obviously haven't read, so we'll ask her to read it to us and we'll take us through it. But would you like to introduce the case and we can go from there?
Certainly, thank you. So obviously Ms. Lester is appearing in person. She does have some additional photos if you want to receive them of the area on the southern side of the seawall, which is subject to erosion, which was discussed in the presentation of Guardians of the Bay yesterday. WILE's in agreement with the description issue of that area, and we've given some thought to that over the last couple of days, and Ms. O'Sullivan will take you through that. So other than that, unless you've got any questions of Ms. Lester, and if you want to receive those photos, I'll ask you to do that. Otherwise, head into Ms. O'Sullivan's presentation, which just summarises her position following the rebuttal evidence of the council and some of the questions that were asked of Mr. Searle by the panel.
Well, okay, why don't we do that? Why don't we hear from Ms. O'Sullivan? We'll basically, which is effectively, as I'd anticipate, the update of WILE's position. So it's
Yes.
Absolutely current, and then we'll figure out where we go from there.
Thank you.
So welcome, Ms. O'Sullivan.
Okay.
Here to take us through your summary statement.
Yeah, definitely, sure. Okay, so as you know, I'm Kirsty O'Sullivan. I've appeared before you a few times now, and there's a few more times to go. But just confirming that whilst it's an Environment Court hearing, I will have read and agree to comply with the Code of Conduct. Now, I'm just going to kick straight into it, and then we can take questions throughout or at the end, whatever is of preference of the panel. So the Coastal Environment Chapter, as you'll be aware, sets out a reasonably broad purpose, being that the purpose of this chapter is to manage the effects of activities and development on the landward extent of the coastal environment. The subsequent provisions contained in the Coastal Environment Chapter then focus primarily on the natural character of the coastal environment. As noted in my evidence in chief, I have no particular issue with the provisions of the Coastal Environment Chapter focusing on natural character, as it would appear that for the most part, other key matters of relevance are already addressed in other chapters of the proposed plan. However, in my view, the Coastal Environment Chapter would benefit from further and more overt references to the NZCPS, so the New Zealand Coastal Policy Statement, and to the relevant chapters of the proposed plan that give effect to it. Mr. Searle, through his supplementary statement, appears to agree with this general sentiment and has proffered some revised drafting. I note that since the council opening, Mr. Searle and I have had a brief discussion regarding potential amendments to the introduction, and that should be how to reconcile any differences. I'll return to that matter later in my summary when I talk about the extent of the Lyell Bay to Mile Point matter. So proposed changes to headings. In my evidence in chief, I recommended some minor drafting amendments to the headings of Coastal Environment Objectives 1 and 3 and Policies 2 and 3. Mr. Searle has recommended accepting my proposed amendments to the policy headings, but not to the objective headings. With respect to Objective 1, he notes, I consider that the identification of the coastal environment has a wider application than the identification of natural character. I remain confused by this statement, noting that the objective to me purely relates to natural character. I therefore do not agree with Mr. Searle's rationale for accepting this change, but I do accept his rationale with respect to Objective 3. I also note that during Council's opening, there was extensive discussion about the headings used in various methods, and that should also be objectives and policies. I will confess to getting a little lost with all the changes being recommended verbally, and am now slightly confused about which methods are intended to apply to which parts of the coastal environment. Perhaps most notable are the heading changes discussed with respect to rules R5 and R6 and standards CE, S1 and S2. To paraphrase the headings, I had taken those to mean that they only apply to areas within high coastal natural character areas that are also within the coastal or riparian margins. I did not interpret these to apply to areas within high coastal natural character areas or areas within the coastal riparian margins. My interpretation correlates with the application of standards CE, S1 and S2, which relate only to areas within the coastal environment, which are also high coastal natural character areas. I am concerned that changes to the headings could potentially change the scope of the methods for which some submitters may not have been provided an opportunity to consider through evidence. If this is the case, I therefore request the opportunity to further consider such changes and provide further evidence as necessary, appropriate. With respect to CEP10, Mr. Searle has considered my evidence with respect to this policy, and while I maintain that the policy is not necessary, the amendments that are such that it would no longer apply to the types of activities being undertaken by Wellington International Airport, and therefore I don't provide any further comment on that matter. Policies CE, P6, P7, and Rule CE8. On review of my further evidence in chief, Mr. Searle has recommended removing CEP7 as a matter of discretion from rules CE8 and 14. He has not recommended it be removed from CER15. He has noted, however, that if the panel is minded to agree that CEP7 is removed as a matter of discretion, policies P1 to P3 should be retained and a new matter of discretion specific to the natural character of the natural open space zone located between Lyell Bay and Moa Point be included. I maintain that this reference is not necessary in light of other policy directives that apply to hard engineering structures in this area and the likely provisions that will fall out of the natural open space zone provisions. Notwithstanding, if the proposed matter of discretion is to remain, as set out in Mr. Searle's supplementary evidence, I understand there will be limited practicable restoration options available with respect to the southern seawall development Wellington Airport's doing, due to the nature of the wave environment surrounding the seawall itself.
What do you mean by that?
Just making an observation that if the policy is to say where practicable include these restoration options, given the nature of the wave environment in that area, there's unlikely to be natural character restoration options available in that area
Well,
They
no, what do you,
sense
what do you mean by wave environment? Do you mean southerly storms that will destroy anything that's not reinforced concrete?
To put it bluntly, yes, yeah. So if extensive planting or the likes is what is anticipated through that policy, it's likely that such planting, for example, will get washed away in the first decent southerly swell. There will be, and Miss Lester, if she talks about the seawall at all, and if we talk about the photos a little bit, there will be some restoration opportunities on some parts, but by and large, it's unlikely to be a practicable option.
So effectively what you're saying is the policy wording is fine, but be aware there's not a lot that's practicable, sensible.
Yeah, correct.
Understand.
So finally, the natural open space zone between Lyell Bay and Moa Point. So Ms Webber, on behalf of Guardians of the Bay, has raised a valid point around what is meant by the phrase, the natural open space zone between Lyell Bay and Moa Point. Where WILE has sought the inclusion of this reference, it has simply been to recognise the location of the existing seawalls that occupy a portion of the natural open space zone between Lyell Bay and Moa Point, and the need for the seawalls to be renewed in the coming years to ensure they continue to protect the airport, excuse me, and various council assets located along and beneath Moa Point Road. As discussed by Ms Lester in her evidence, which was a attachment to her earlier statement, the seawall renewal project will result in the seawall occupying a slightly larger footprint. This will ensure that the wall is appropriately designed to protect against coastal inundation events and the effects of rising sea levels. Accordingly, it is important the proposed plan not only recognises and provides for the existing seawall, but also provides a consenting pathway for a slightly larger footprint. I generally support Ms Webber's suggestion that the area being referred to as natural open space zone between Lyell Bay and Moa Point requires further clarification. I also agree with Ms Webber that the intersection of Stewart Drive and Moa Point Road seems a logical endpoint. In my view, a similar endpoint should also be included for the eastern end of Lyell Bay, i.e. the eastern end of Lyell Bay Beach. Now, Mr Searle and I have had a brief discussion regarding this matter and how to integrate such a description into the proposed plan without creating overly complicated references within the relevant objectives, policies and rules. One option that we're both going to turn our mind to is whether the area should be referred to as the Moa Point seawalls, with the definition providing further detail about where this area specifically relates to. Mr Searle and I intend to continue to look at this over the coming weeks and could report back in his closing, if not earlier. Mr Searle and I are also aware that this general natural open space zone between Lyell Bay to Moa Point descriptor has also been used in other chapters of the proposed plan. Consideration will therefore need to be given to how such a change in terminology could be integrated into the wider plan, such as through a Clause 16 or Clause 16A amendment. Mr Searle and I also have broad agreement that once this matter is resolved, the difference in opinions regarding the drafting of the introduction, which is the matter I deferred earlier in the summary, could be readily resolved by including a reference to the new term in the introduction. Now, Mr Searle hopefully agrees with my summary there, and I'm sure he'll have an opportunity to clarify if I have mischaracterised the nature of those discussions at all. Finally, with respect to public access, Mr Searle and I appear to be broadly aligned with respect to the recommended changes to the public access provisions. Drawing on the line of questioning of Mr Dace during the second day of Council's opening though, I would support a further minor amendment to policy PAP1 to ensure it's not read as an absolute requirement, citing that policy P3 does provide some exceptions to the provision of public access. And that is my summary. Can I just take a moment to make a couple of minor amendments to my evidence in chief? Just I've found a few errors. Okay, so paragraph 39, there's a reference in there to rule CER 12. That should.
Go slow, I'll turn it up.
Yeah.
See,
So
12.
yeah, that should be CER 8.
39. So it should read 8, 14 and 15.
Correct.
Right.
And then the only other amendment is in the Appendix A, where I provided some marked up changes to the provisions. If you go to Rule 14.2. And there's blue struck out text, which are my changes. The reference in the matter of discretion to CEP7 should be completely struck out in blue text. And a similar change should be made to 15, Rule 15.2.
Okay, that's thank you for that, Ms. O'Sullivan. What I propose to do is to hear from Ms. Lester, then break for 5 minutes, because I'd like to put your summary statement, Ms. O'Sullivan, next to the plan provisions and make sure I understand exactly what you're proposing. As you went through it quite quickly, and
Yeah,
busy trying to understand the first one while by the time you'd already got to the third one, and so I never did understand the first one. So what I'd like to do is hear from Ms. Lester, and then break for probably 5 minutes while I and my colleagues ponder what you've said and where that takes your evidence. But I think we've got plenty of time to do that. So we'll hear from Ms. Lester now. Thank you for the photographs, which we will receive. Thank you. Which emphasise the point. Lester, is there anything you want to say? So I had 2 minor questions of you, but is there anything you want to say to them?
Happy to just answer your questions, actually. My evidence was it was previously put forward in the previous hearing stream.
Two entirely factual questions. Refer at paragraph 3.3, the airport being transferred from the Crown to the Council. When did that occur?
I think that was in the early 90s. Amanda might be able to answer that better than I do.
Like it's not particularly important. You just satisfying my curiosity.
Yes, I think.
Yeah, it was the early 90s.
90s.
I think that's right. Yeah.
And the second factual question is, what's an ACMON?
It's a big concrete structure. So if you have a look on, I've got some photos on page 8 of my evidence. So look at number photo 5.
Just a minute.
Those concrete structures there, which hold up the seawall, the concrete units, armour units.
Yeah, they're not blocks, they're more like, irregularly shaped concrete. Gotcha.
Yeah, and they all fit together. They don't look like they fit together in a particular way, but they do. And
Like
they
they're
hold
like a
the cement.
jigsaw,
Like a jigsaw.
a concrete jigsaw.
Yep.
Any other questions from Ms. Lester team? Right, so we will thank you, Ms. Lester.
Good.
For that, we will, as I say, break for 5 minutes and study these plan provisions, and then we'll go from there. We'll resume the hearing, thank you. I think that having got my head around these plan provisions, I better talk about them first before I forget it again. Ms. O'Sullivan, as regards Rule 5 and 6, I wonder if, like, there is a degree of confusion here, but I wonder if, from the airport's point of view, this might be something of an academic point. Immediately before you, we heard from Ms. Foster from Meridian, whose concern was about the lack of clarity as to the extent to which the coastal environment provisions and indeed the NFL provisions, which are not relevant to you, apply to renewable electricity generation. The discussion of that point has produced advice from the reporting officers that the intention is that nothing in these chapters, objectives, policies or rules, applies either to REG or to infrastructure, and that the REG and infrastructure chapters operate as a code effectively, and that this prompted us to discuss both with the reporting officers and with Ms. Foster how that intention might be better captured, as I put it, stating in words of one syllable that nothing in these chapters applies to REG, that REG being Ms. Foster's concern, and infrastructure, because that's this. If you had a statement of that, you couldn't not say the same about infrastructure, because that would then lead to implications that the absence of commentary was itself material. So the officers are busy thinking about how exactly that might be framed. But assuming the end result is that in the introduction of the chapter there is a statement that nothing in this chapter applies to infrastructure, could you bear with some equanimity the intricacies of how the rules in this chapter were in fact framed?
So this is a very, very good point, and it is something that I anticipate will be discussed a little bit more at hearing stream 9. So if I can take the panels back to, I think it was hearing stream 3, and Mr. Kyle presented some evidence, and I have subsequently presented some evidence on how the infrastructure chapter is drafted. And it currently, the introduction currently excludes airports and airport activities from its application. It's not confined to airport and airport activities within the airport zone. So there's a degree of uncertainty around whether the airport can actually engage with the infrastructure provisions of the infrastructure chapter. There's also a little bit of a degree of uncertainty around whether a seawall in itself is infrastructure, and whether that can engage the infrastructure provisions. So essentially, Wellington Airport's been appearing at lots of different hearings, talking about the seawall, because it isn't clear which, at this point, and unfortunately the infrastructure hearings, the second to last one being heard, isn't clear where that will fall. But in my view, doesn't, provided there's a consenting pathway through, be it through the normal provisions, other provisions, or the infrastructure provisions, I'm reasonably comfortable. It's just where should that sit? So that's I guess where my evidence for this hearing is coming from. So does that help answer your question?
Yes, thank you for reminding me about Mr. Kyle's evidence. I had forgotten that point. And indeed, because the seawalls are not actually in the airport zone, an exclusion for the activities within the airport zone wouldn't actually solve the problem either. Like if the so even if the exclusion or the clarification we're talking about were expanded to say that the airport zone similarly operates as a code, and I need to think about what's actually in the airport zone provisions as to whether it's sufficiently comprehensive to do that anyway, but it still wouldn't solve the problem of the seawalls because they're not in the zone.
Correct.
Okay, well, on the assumption, yes, there has been a bit of confusion about what exactly the officer's intention was, because there was a typo in Mr. Searle's rebuttal appendix. My understanding, based on the discussion we had on Monday, was that R4 sets up a general exclusion, but leaves for subsequent rules to talk about vegetation trimming or removal within high coastal natural character areas and within coastal or riparian margins, and that the intention was that R5 and R6 would fill that gap, because if that were not the case, then R8 would apply, testing whether it's permitted activity in the underlying zone. I'm not sure whether vegetation clearance in the natural open space zone is a permitted activity. Maybe you could tell me that.
Cannot recall that off the top of my head.
I'm shocked, Ms. O'Sullivan, that you don't have a photographic memory of every rule in the Wellington plan.
I will go by the end of this process, I'm sure.
Wonder if Mr. Dash can assist us since he sat on that natural. So we were agreed that no one has a photographic memory of this plan, unsurprisingly. So I think that the intention of the reporting officers was that R5 and R6 would apply within the coastal margins. I don't think you're worried about riparian margins. I'm not aware of any streams across the airport site. But assuming it did, do you have a concern about well, it says exotic vegetation removals permitted, so that presumably that wouldn't be a problem. Do you have a concern about indigenous vegetation trimming or removal being subject to S1? And if so, perhaps I think you need to tell us what that concern is, and how you're suggesting that it might be addressed.
So if you turn to S1, again, it comes to a interpretation matter. if you turn to S1, when I read the heading of S1, it talks about Indigenous vegetation removal, trimming or removal within the coastal environment and within high coastal natural character areas.
So that's not, so the first point is that that's not a match with the rule. If the rule is expanded to coastal and riparian margins, so too does the standard. That's a that'll be, well, I think we may have discussed that on Monday, but I've forgotten. So assume that the rule is tweaked to make that consequential change, so it clearly applies.
And the standard applies, because that was going to be my comment, is that if the rules changed to apply to the coastal environment, the standards only apply to high natural character areas.
Like I think the standard would need to be amended as a consequential change. Assume that's done for the purposes of this discussion. Do you have a concern about the substance of the standard?
As I say, I hadn't turned my mind to it in detail because I didn't think it applied. So I'll try and do this briefly off the.
Well, if you haven't thought about it, I think that would be unfair. But I do need to know what you think about it, because this is the track that the reporting officers are taking us down. So I will give you time, and the question is how much time you need to give us a memo or a supplementary statement on CES1, assuming it applies to the coastal margin to the area of interest to the airport. And the only question is how much time do you need?
The end of next week. I could do that by the end of next week if that is within an acceptable time frame for the panel.
1 o'clock on the 10th of May, which is Friday, I think.
Yeah.
So as I say, the working assumption is that standard would apply to the airport seawalls and or to vegetation clearance of indigenous vegetation if there is any within the airport seawalls. And so the question is, what implications does that have? Because this is a consequential change, I think it's open slather as to what you might suggest be done as a further consequence of adding that. So give it your best shot, and by next Friday.
Okay.
Turning to your paragraph 15
of my
of your summary statement, there's it says this reference. What reference specifically are you talking about?
The reference to policy CEP7 as a matter of discretion.
We discussed that with Mr. Searle and suggested to him that perhaps you had a point. So do you have any thoughts that you wish to share with us as to his suggested additional matters of discretion?
So I think in his supplementary statement, he did put in a new matter of discretion if the panel was minded not to include policy 7. That's the one that I have referred to around in my paragraph 15 around there being limited practical restoration options. So I'm comfortable with that matter of discretion. Policy 7 is quite descriptive And a lot of those matters, in my view, have been more broadly applied. In my statement of evidence, I provide a paragraph reference through other provisions in the plan that relate to hard engineering structures. So that's
like you're not you're non-specific as to what other provisions you're talking about. Can you give me some examples?
I'll just pull up my and the reference, because I do state it in my statement of evidence. So the reference is in paragraph 37 of my evidence in chief. And there's a footnote 16. So there's other policies such as the earthworks chapter from the panel recommendation version of the earthworks chapter, policies 13 and 14, and policies 28 of the coastal environment chapter, which relates to hard engineering structures, I believe the terminology. And then of course there will also inevitably be provisions within the natural open space zone.
C28. I think you mean C26. There isn't a C28.
I was looking at the track to change version, so
Yes, we had the same discussion with Mr. Searle. Do you think that it's about hard engineering? Okay, I understand. That's all I had on the supplementary statement. Anything else, commissioners?
Thank you, Ms. O'Sullivan. I have to say I'm still a bit confused. Your para 14 in your statement this morning references Mr. Searle recommending removal of CEP7 as a matter of discretion from Rule 8 and Rule 14. It may be something to do with version control, but the attachment, the Appendix A to the officer rebuttal that we received actually doesn't have any reference to CEP7. Whether that's come out incorrectly from Mr. Searle, because I think it was certainly in your evidence in chief, Ms. O'Sullivan, that you had a blue line removal of reference to P7.
Yeah, I think there's some version control issues, I think, because this, if I can recall correctly, the section 42A recommended the tracking and the rebuttal evidence wasn't quite correct.
Can we go slow? Mr. Searle's going to hopefully clarify what he was intending, and then we'll get your comment on it, Ms. O'Sullivan.
I think, I think what's happened here is that I haven't struck out the section 42A recommendations. I've simply removed them because in an attempt to keep it clean.
So you haven't shown from 42A to rebuttal, you've shown from notified to rebuttal. So, so it went in and came out again. So,
Okay, I'm sort of beginning to get a little bit clearer now, but he hasn't recommended it to be removed from R15. When I look at R15, it's still in there, CEP 7.1 and 7.2.
that's right. And I discussed that with Mr. Searle on Monday. Because it was there to begin with.
That's notified.
Yeah. Okay. And you also mentioned, Ms. O'Sullivan, in your heading above paragraph 14 in your summary this morning, you mentioned CEP6 in there. Was it because CEP6 is just included with CEP7? Isn't it all about CEP7?
It may be in here. So let me check my summary.
I see that Mr. Searle's R8 does refer to P6 as a matter of discretion. So query whether that is, do you have a view as to that, whether that is required?
Just, okay, so if I can respond to Commissioner Dacia's comment, policy PCP6, that should not be in my summary. That was just legacy from using my primary statement as the template for my summary. So you can
Okay.
strike out PE6 from my summary.
Thank you.
And sorry, Commissioner Robinson, what was your question?
The matter that Rule 6, no, Rule 8 currently has reference to CEP6 as a matter of discretion in Mr. Searle's rebuttal version. And the question is, given that that is an enabling policy, should that remain a matter of discretion in your opinion?
In Rule 6?
In Rule 8.
Rule 8.
Oh, Rule 8. I don't have any difficulties with that. That allows kind of the broader, I guess, benefits of those activities to be taken into consideration as a matter of discretion.
Okay, so that's a tick. Any other question, commissioners, on this summary?
No.
Oh, sorry. Were you finished?
Yeah.
Okay. As O'Sullivan, I just done my way through what notes I put on paragraph 9. You support mapping the coastal margin. Is there an issue with doing that? Because the seaward boundary is a movable one in High Water Springs.
The challenge is the trade-off, in my view, between knowing where the plan applies. So yes, mean high water spring will move, but then that also means that boundary line moves, and at any given point in time, it's difficult to know where those rules apply. So that's why I was drawn to having the area mapped. The coastal margin may expand and shrink, I guess, if you were to map it. So it may not be 10 metres for all of time, and it might need to be reviewed periodically. But from a plan implementation perspective, if you can click and you know where you are and you know if you're in or you're out, that does make implementation much easier in my view.
The problem is that if you're at 10.1 from the mapped, like there may be a mismatch between the words and the maps, and so the question is, which is determinative?
I would want to say it would be the maps, because the purpose of showing the maps is to provide the certainty to plan users. So if you're going to, it may mean that the definition may need to be amended to reflect that. But if the purpose of mapping it is to provide clarity, then you don't want that to be able to be moved, I guess.
Referring to your amendments to the introduction, I think that Mr. Searle may have accepted this, and I forgot to ask him about it, but I'll ask you in lieu. I wondered whether the insert was in the wrong place. Sorry, that's to be clear. On the second page, where you've added the sentence starting protecting natural features and landscapes within the coastal environment from inappropriate subdivisions development is, etc., managed by the CPS. The existing text, council has therefore identified areas of ONLs and landscapes. Of course, not all of the ONLs and landscapes are within the coastal environment. I don't think. Maybe they are. But the obligation to identify ONLs and ONFs comes from a different place than the obligation to obligations of the CPS. It's rooted in 6B.
6B, correct.
So,
yeah.
so I was thinking that maybe that insert needs to be further down in that paragraph, and maybe following that sentence.
I have no particular difficulties with that, and I'd agree around your comments around section 6B.
Paragraph 25 of your evidence in chief. I'm wondering if you're missing a negative. I'm not sure this is what you meant to say.
Yes, I believe there does need to be another word in there. Perhaps inappropriate. Rather than appropriate.
Yeah, there being quite a difference between the two.
Just a little bit.
And the last point, whether you address this or Ms. Dewar comes in, because she's made a further suggestion. This relates to the penultimate paragraph of your marked up introduction, starting the framework below. This is really how do you amend this text to be consistent with the fact that it now includes the natural open space zone. It's by reading. That's what you're trying to do, isn't it? I think.
Correct. And that's the one that Mr. Searle and I had a brief discussion about yesterday. And if we can come up with some better way of defining that area of open space zone without saying something like the natural open space zone from the eastern end of Lyall Bay Beach to blah, blah, blah. So if we can come up with a more succinct way of referring to it and then including that reference into this introduction, it can be a reasonably easy amendment to that paragraph.
So the message is that you and Mr. Searle are on the case.
Correct. Yep. We'll come back to you on that.
Thank you. Ms. Dewar, I'm not sure if you're happy to leave it to the planners, but I did wonder, with your suggested redrafting, whether referring to the airport really covered it, because most people wouldn't think of those seawalls as being part of the airport.
No, and look, I agree with that. We were just when I drafted that, it certainly improved it, and because the description of the airport in that definition of RSI is to the entity, and then we've been having other discussions in terms of other documents such as the RPS about what that means and what infrastructure is included within that definition. That seemed to be a step in the right direction, but obviously since then we've had some further thoughts about it, and it does appear to me, and now Kirsty has outlined that it's better to actually have a succinct term for the area and then define that more thoroughly in the definition section. We thought about having a map, for instance, but that seemed to be a wee bit more difficult and not as easy, because it would have to go into the planning maps, and that seems to be a bit more a bit more tricky. So the definitional methodology seemed to fit best and to be the most efficient way of dealing with it.
Okay, so we'll leave it to Ms. O'Sullivan and Mr. Searle to sort that out. Any other questions from Ms. O'Sullivan?
Yeah, just one. Again, I'm a little bit confused in terms of version control. P10, CEP10. Your suggestions to add quarrying, and I see Mr. Searle's rebuttal doesn't have that inclusion. What's your understanding of where this has actually landed?
So my preference is for P10 to be deleted, but if it is to remain, to include those activities that they're concerned with. My understanding is that Mr. Searle, from his rebuttal, has the words in his rebuttal rather than the appendix. He has agreed with that. But I think there might have been some other changes to that policy as well that were discussed during council opening, but I got a little bit lost and confused with that.
Yeah, we'll unpack that. Thank you.
In the nicest possible way, you relaxed when Mr. Searle confirmed that it would be restricted to quarrying and plantation forestry.
Correct. Kenneth.
Anything else? That was your only point, Lindsay? Yes, you had something? Yep.
Me?
Yep. Yeah, sorry. One of the problems, I'm looking directly at the screen. So yes, Ms. O'Sullivan.
Sorry, I meant to raise this just when I did my introduction, but I understand during the council opening there were quite a few questions around the efficacy of the coastal environment provisions, and that was one of the key themes that came through in Wellington Airport's submission. Now, again, haven't gone into that in any detail in the evidence because so long as there's a pathway for what Wellington Airport needs to do, I'm reasonably relaxed. But if the panel is looking for scope to make some reasonably broad changes to this chapter, it might be worthwhile having a look at Wellington Airport's submission because it is quite broad and did seek to delete a lot of provisions in their entirety.
Thank you for that. I think that just check. I think that might be us. Anyone have any other questions for the WILD team? So that is all we had. So thank you all for your attendance, both in person and at a distance. And I look forward to seeing you in Stream 9.
Thanks very much.
Thank you.
Thank you. For the quarry team sitting patiently up the back, we'll take a break and have a coffee, and we'll restart at 11:05.
Looking forward to the end of this.
See ya.
This is probably
We'll resume the hearing. We have the team from Horokiwi Quarries. Ms. Whitney, I trust you have your boys all organised.
Can but try.
How would you like to proceed?
Thank you. So we'll just do brief introductions and then I'll hand over to Mr. Bray in terms of his landscape evidence and assessment, obviously because the coastal line seems to be the major outstanding issue. And then I'll just wrap up with some planning points and maybe respond in some of the questions and issues I heard come up at the hearing over the last couple of days. So just by way of introduction for the record, obviously I'm Pauline Whitley, a planner at Boffin-Miskell, and I'm joined by Ross Baker, the quarry manager at Horokiwi Quarries. Now, Mr. Baker hasn't provided any written evidence to this hearing stream, but he did provide some for hearing stream 6, which the panel can draw on if needed. It's really just operational evidence in terms of the quarry operation and history and so forth. So Mr. Baker's available to answer any questions in terms of operational company evidence the panel may have. And then I'm joined by Mr. Shannon Bray. So Mr. Bray's a landscape architect at Wayfinder Landscape Planning and Strategy Limited. So Mr. Bray's obviously provided comprehensive evidence and he will provide a summary today on that, and he also has listened to the panel questioning the council expert, Mr. Anstey. So Mr. Bray will just briefly comment on that as well. So before I just pass over to Mr. Bray, if I can just confirm in terms of the panel direction or maybe suggestion that the experts get together. So we emailed Mr. Searle on Tuesday night just offering the availability of Mr. Bray and some times he was available to meet and discuss. We just haven't heard back, so obviously our position is that Mr. Bray's evidence stands in terms of the line as defined.
That's right. I'm at the end of the start of yesterday, you may not have heard this, I said to Mr. Searle that as regards Mr. Anstey going on site, that was a matter for him if he thought he would benefit from that in terms of preparation of the council reply. That was over to them. As regards the CE line, the other suggestion, not direction.
Yes, suggestion, correct, yeah.
I made was that Mr. Anstey had tabled in effect a compromise position, had described a compromise position, but had not mapped it, of carving out the active quarry area. And I said to observed to Mr. Searle that of course left open the question as to how at either side of the carve out it was joined to the balance of the coastal environment, and that he might benefit from discussing that with Mr. Bray. But again, I haven't directed that they do that. I just observed that seemed to me to be an open question, and one which I'm going to ask Mr. Bray to comment on the hypothesis that we find merit in Mr. Anstey's suggestion rather than his more comprehensive solution. But so as I say, appreciate your position. Thank you for that. So we should hear from Mr. Bray.
And if we can just confirm, that Mr. Bray is open to engaging with Mr. Anstey as well, going forward before the right of reply. And if Mr. Anstey wants to go out on site, Mr. Bray won't be there, but Mr. Baker can organise that in terms of him going out. So invitation's there.
Appreciate that. We'll take that as a given. Take as a given that Mr. Bray would contribute to any discussion with fellow experts in terms of his obligations under the code. That's what I would expect.
Yes.
So, Mr. Bray, over to you.
Morena, thank you. I did prepare a bit of a statement, which I think probably is worth me reading to you, and we can provide a copy of it as well. It probably covers some of the questions that I'm anticipating you might have, so it might just be a bit of a lead in if you're comfortable with that.
Absolutely.
So although I wasn't
Well, subject to how long it is.
it's taken me a couple of days. No, that's 2 pages.
2 pages is good.
So
And
yeah,
who would like a copy?
cool. We'll get that to you. So yeah, I wasn't in attendance this week, but I have watched the recording of your questioning of Mr. Anstey, and I've also been briefed on various aspects by Ms. Whitney. And we just talked about the meeting with Mr. Anstey. I guess I want to generally agree, firstly, with the broad concepts about managing landscape that Mr. Anstey promotes. And I'd say Clive and I are old mates, and we have spent long glasses of wine talking about the challenges of landscape management, particularly in the legislative context. And I actually agree with him when he says landscape lines on a map are incredibly problematic. Landscape, as he has said, as a functioning whole, it's coherent, there's values based. But I guess where we differ slightly is that we live in a world defined by lines. The coastal policy statement and policies at regional district level require us to define the coastal environment. We have to draw a line, even though we don't want to. And I also appreciate the challenge that councils have at drawing these lines at such a broad scale, and that was discussed on Monday. It's necessary to have a simplistic methodology that can be applied without need for fine-grained assessment, because, as Mr. Anstey said, to assess every site across every area of the district is simply impractical. But in my experience, this is what a submissions process is for. It allows councils to undertake the broad scale assessment and then invite landowners in the community to question or challenge any assumptions. And that's what we have done for Horokiwi. However, it seems that both Mr. Anstey and Mr. Searle appear reluctant to then consider such submissions because of a potential knock-on or precedent effect. Mr. Anstey suggests future developers could challenge where the line goes, and Mr. Searle suggests it could have implications for such sites such as the port or the airport. It's this concern that appears to be the key issue rather than the landscape values themselves. Firstly, I'd point out that other such parties or landowners have not submitted on their matter, so we're only talking about Horokiwi. But let's put that to a side. As I set out in my evidence, what matters most are the values being assessed. These are well covered by Policy 1 of the CPS, and Mr. Anstey in his supplementary evidence noted the approach applied in the 2014 Boffin-Mitchell report and that of Mr. Bray are consistent with Policy 1. He goes on to agree that the natural character in the area I have assessed across the Horokiwi site is low. And I must admit I was interested that Mr. Anstey admitted on Monday that he hasn't actually assessed the values. Rather, he's relied solely on the Boffin-Mitchell report. So essentially the generalist methodology undertaken by Boffin-Mitchell. Let's just for argument's sake consider utilisation of my more detailed methodology across the airport or the port. In other words, assess these sites against Policy 1. In your own words, sir, I don't think you need an expert to determine that these are within the coastal environment. Indeed, both have protruding features into the CMA. The adoption of the detailed methodology for these sites would unlikely change that outcome. It would probably just guide how far to set back the line. You also talked about urban areas such as Kilburnie and some of the CBD being under the CE, being in the CE, and referred to the Boffin-Mitchell methodology, which highlights the challenges associated with such situations. As you mentioned, this is often when you need expert assistance to define the line we don't want to define. And whilst I haven't directly assessed these situations, I generally agree with Mr. Anstey on flatter areas. It is evident you're in the coastal environment, even a couple of streets back from the coastal edge. This is displayed visually in vegetation choices around homes, seeing marine birds, but is also experienced by the feel, the smell, and the sight of the sea. I recently had coffee outside a cafe in Seatoun, joined by a couple of seagulls in the brisk salty air. The name Seatoun also contributes. But the line is blurry and your experience will alter from one day to the next. Defining a line in these situations is problematic, but I'd also note that the line drawn by council in these areas isn't being challenged. Horokiwi isn't one of those situations. It sits behind a clear defined ridgeline, which you can see more clearly in the cross sections I provided with my evidence. And when you're within the working quarry behind this line, there is little evidence of being near the coast. The activity of the quarry is all consuming and its impacts have changed its landscape values. This hasn't happened recently, it's been operating for 90 years and it will continue to operate beyond the life of this district plan. Mr. Anstey argued that time is irrelevant, that 100 years ago Kilburnie was a swamp and the coastal processes that created it remain evident. But I would argue, couldn't that apply to all of New Zealand? Are we not a coastal nation? I regularly walk from my house up to Mata Peak in Hawke's Bay, some 400 metres above sea level, 6 kilometres from the coast. On this walk, there are many places where intact seashells are clearly evident in the paths and the rock faces. And the morning easterly breeze has a bitterness of it having come from the sea. It's not a coastal environment. It once was, it's now altered. This will happen at Horokiwi. As I set out my evidence, it was once in the CE, but time and activity has changed this, and it will change again sometime in the future. These changes, perhaps infilling or replanting of coastal habitat, may mean it returns to the coastal environment in the future. District plans, policies and lines on a map change and adapt over life cycles. This is why we need to fundamentally come back to the values experienced today. From what I've read and heard, Mr. Anstey and I do not disagree about the values. In the quarry, coastal values are low or non-existent. In my opinion, council seek to apply a more philosophical method to determining where the CE line exists. By Clive's own words, approximate and based on past history. Rather, my methodology is based on the values present today and the values likely to be present for the life of the district plan. I'll leave those thoughts with you and question me away.
So what you're really saying is that Mr. Baker has made a hell of a mess with his big toys, digging a big hole, and what was there before is entirely historical.
Well, quarries do make a mess.
Yes, I think that's a given.
Yeah.
The thing, and Mr. Anstey has sidled up to that recognition, recommending, in effect, as I said, a carve out for the active quarry area, but he maintains the position that either side maintain coastal values. And so I think that what I'd like to do is focus on the areas either side. And the first thing I'd like to do is to take you to your cross section, make a request of you. Helpfully gave us an A3 version, the series of cross sections. And I want to clarify as Whitney's evidence provides a map saying you've altered your, I'm not sure of your view originally, but altered the view, and so the requested CE line has shifted in a few places and told us that the red line on your sheet 12 shows the shifted version. Is that, so just make sure that
That's correct.
Hmm.
And if I may, the amount we shifted it was a few meters.
Yeah.
And it was simply that when we drew the line initially, we used a GIS tool. We did it in a 3D model using topography and assessed values. And then through this exercise, we realized we actually had a bit more detail that we could use. So we said, well, if we've got the more detail, let's get it more accurate if we can.
so that
I mean, it's difficult. It's a blurry line, but
the I'm not arguing. I understand the process. What would be of assistance, however, is if you could give us a revised version of the cross sections that showed not just the council's line and your revised line, but the original line, so we can see them on the cross sections.
Oh yeah.
Because,
yep,
as I understand, what you were trying to do with the revisions was to reference the first escarpment and then move back from it.
That's correct.
So it would assist if could. The next question is, how long would you take to provide that? Because I want to be clear when we're going to get it. Like I'm not saying it's desperately urgent, but tell me when you can conveniently do that, and if it's too far away, I'll tell you that.
My team's going to do it, and they're going to hate me. Probably the end of the day.
What's that?
End of the day. End of the week. Yeah, it's not a big job for us. We've got the model. We can map it pretty quickly. It's not a big job.
Well, why don't we say close the business tomorrow?
Certainly. Yeah.
Right, so it's just the 3 lines. The council's line is notified, the line in the submission, and then the line in the evidence.
Basically this.
Yeah.
So that we can see where on the cross section you've shifted.
I originally meant
to.
Yeah.
Yeah.
And if the answer is that it's at the scale of the cross section, that it's too close to tell, then maybe put an asterisk.
Yeah, it'll possibly be that.
Some of them are more material, but it'll depend on exactly where the cross sections are.
Yes, I think I noted in my evidence the cross sections that were affected.
It's
anyway, we can provide that for you.
and as I say, if it's so close that it would just mean that the red line's thicker.
Yeah.
Then put an asterisk next to
Sure.
saying different but not meaningfully different.
No problem at all.
And so looking at where the south side, well, let's just start and record what my understanding and make sure I'm right. My understanding is that where you have shifted the line, is it northeast of Horokiwi Road, you're essentially following the ridgeline. Mr. Baker took us up to an elevated view. We were looking across the quarry, and there appears to be a ridgeline going down from the neighbouring property where there's a big green shed.
Mhm.
Is it Howard?
Howard's property, yes.
Howard's property. It appears to be a ridgeline that goes more or less at an angle towards the coast. You're following that.
That's
rather
correct.
than cutting across.
Yeah, I mean, Mr. Anstey laboured this point about topography is probably the most defining thing that we have outside of I guess, the worked area of the quarry. So that is the defining line that I've used. That is indeed the first ridge line that you come to. And so we've tucked the line just over the crest of that ridge line. That's evident in the cross sections 4, 5 and 6.
And moving to the other side, to the other end, it was apparent to us that where the sea line cuts through the base of that the bottom end of Newlands developed area, it's significantly higher than the quarry land where what Mr. Baker refers to as the mud pool sits. And the council's line, or the Boffamiscal line, cuts sort of inland to try and join the elevation, whereas you're going effectively straight across a gully and then across the seaward edge of the small plateau that the mud pool is on. Now, that seems to me to be more of a judgment call as whether that first escarpment is the correct basis, or whether judging from or whether you use the elevation to the south as the guide and find where do you match that elevation. Is that a fair comment? And what's the rationale for your judgment call?
Yeah, I think it is a fair judgment. I think even the council line has to find the elevation again, because across the Horokiwi site, it's no longer there. So I've stuck with as much the natural landform as I can until it gets, to the point sort of immediately in front of the quarry, which is where it deviates. An alternative, if you were to just apply the first ridge line, is, you could take it right the way to the top of the hill, long way back. But in my view, that wouldn't actually map the coastal values, because it's, that's an extreme version in the other direction, which would follow topography. And what I'm saying here is you can't just apply the topography rule here. It's too complex to try and use that simplistic method.
Mr. Anstey's evidence is that, at least in that southern area, the land, or effectively the bush that the mud pool carves into, still exhibits coastal values. What's your response to that?
It does, to a degree. It is quite modified, and I think that's a great example of where drawing a line is problematic, because it's a bit blurry. I would go back to what Clive says about coherence, and actually what we're trying to do here is map a coastline that isn't just in front of the quarry site, but is much longer. And there will be bits that you can get it quite accurate, and there'll be bits that you can't. So get the bits that are accurate right, and then you have to piece it together from there. And that's really essentially what we've what we've done. And we've tried to use the topography as the only fallback we have in that sense. I mean,
Questions about Mr. Dash?
I'm interested in your comments that you said right at the start in terms of the mapping of the coastal environment within Wellington City, forgetting about Horokiwi for now, if you like. And the questioning that we had of Mr. Anstey about, seriously, is Kilburnie Town Centre part of the coastal environment, which is where it is? And I was interested in your comment that you had about, 2 streets back, there might be some coastal vegetation, there might be a few seabirds and so forth. But how do you actually draw the line in between what is seriously up, has coastal influences and what doesn't? In a pragmatic view, because when it comes down to it, the coastal environment overlay in the plan has some implications for some sorts of development, and where you should reference coastal influences in your decision making. So I'd be really interested in your comment about how from a workability point of view, if there is this uncertainty between, if you know Kilburnie, if you're in between Tahi and Rua Street, in between the two. So, what's your view on the efficacy of the coastal environment where it really does extend beyond what we would know as the coastal margin?
I mean, you're right. It's complex because, as I said, we live in a world where we need the line. Drawing the line means a lot, but it's really difficult to do it. I mean, my view is that generally, when you have a really established urban area like Kilburnie, the bit that matters is the immediate coastline and probably back to the first set of houses. That's what we're interested in managing and looking after. It's that direct interface with the coastal edge. But beyond that, behind the next row of houses, there is probably some influence. And there might be, a sports park or a reserve or something that extends quite a long way in that, and that might have more coastal influence. But generally, my feeling is that it's most evident up to the sort of the back of the first row of buildings is a practical way of working it. That's how I would like to operate it.
Okay, so but that departs from the Boffa-Miskell report, which the council has been relying on.
Well, I don't think it does. The Boffa-Miskell report has a very clear drawing that says that's their drawing 3, which says actually this is really difficult, this bit, and we can't really tell you what to do. That's essentially what the Boffa-Miskell report says. So they've going with the values.
So they've erred on the side of caution.
They have.
If in doubt, leave it in the coastal environment.
Yes, that's what they've done.
And in relation to Horokiwi, the doubt, they've done the same because of the doubt.
Correct. And the broad scale.
I know you were, we know each other.
Yes.
But I know you were at Boffa-Miskell. Were you around at the time of the production of this report? Did you have any involvement in it?
I was around actually, but I wasn't involved in it. It was the Wellington office that did it. I was in
Yeah,
in
no,
the
I
office,
think it
yeah.
was Mr. Evans, if you like, the technical lead for it.
Yeah, we had quite a lot of discussions, Chris, that, you know, the national policy statement had come out and then it just introduced this concept of natural character, which nobody knew what it was. And so there were quite a lot of discussions internally where we tried to define what that actually meant and draw it out. And that was really useful because I think we landed on a definition for natural character. And then from that, Mr. Evans then sort of took it further to say, right, okay, then how do we map the environment? And we had a broad level of agreement. And again, coming back to that third drawing, I wasn't involved in the actual production of that, but I do still agree with it that that's where you've got the biggest challenge. It's not that clear cut.
So it's only when you actually get to, say, a development proposal of any description, you would work out the applicability or otherwise of the natural character values in the coastal environment and as they would apply to a particular site.
Yes.
And how helpful is that to a decision maker?
Not.
It's not.
No.
Okay. All right. I recognise that we've got limited submissions on this issue, but I'm just interested in you as the only other landscape architect apart from Mr. Anstey who's before us. So yeah, thank you for that. I only had an additional couple of questions because the chair is. We had a very beneficial site visit. I hadn't actually been to Horokiwi before, but obviously here in Stream 6 it was a subject to a lot of it. But I'd be interested where you go through the various attributes that there are in Policy 1 of the NZCPS and under 1.2.E. And your bottom conclusion where you say, overall, consider the active quarry site as very limited coastal vegetation and habitat. That responds to that. The area with more significant coastal vegetation is the coastal facing hillside above State Highway 2 at the base of the active quarry. When you're saying that, it's not necessarily about the vegetation though, is it? It's about how visible it is, where you can see it from, as opposed to just the vegetation.
Oh, yes, absolutely. You can have a coastal environment like a dune system that's got very little vegetation on it. But in this situation, that vegetation is what really defines the coastal environment around the harbour, because it's so continuous and so present. And then that vegetation leads on to, bird habitat, bird movements, those sorts of things. And also has influences on air movement and those sort of characteristics as well. So, no, you're right. It's not just about the vegetation.
Yeah. So, in terms of views into the site, and having been there actually onto the quarry site for the first time, so the views of the quarry are if you're in a boat in a certain part of the harbour,
correct,
or potentially you've got a longer distance view from sea view. Or from, and then you've got views from the other side, Point Howard sort of area up to the top there.
That's correct.
So in terms of the landscape significance of the coastal escarpment, it really is just that first line. And I think that's a point that you've made consistently, that from a landscape perspective, that is the most value from a coastal perspective.
Across the front of the Horokiwi, yes.
Yeah. Okay. Thank you. And I think my other question was going to be about your last paragraph under 1.2 F as well, but I think you've answered that in relation to my previous comments. So I don't have any further questions. Thank you.
Picking up on the Commissioner's question, tapping your view, we talked about Kilburnie, going back the first row of houses. Red Kit's Park. where is the coastal environment line in relation to Frankett's Park? In your opinion?
Oh, so this is where it gets so difficult, and you need to balance, you know, a particular area where you know it's very clear, and a particular area where it perhaps isn't so clear, and try and, you know, balance the two, which really comes to the point about the north and south. It's probably not so clear there. I mean, in a park environment, it could go quite a long way back from the coast.
But in the sense that Frankett's Park to Jervois Quay, how much further?
Yeah.
Further inland than Jervois Quay do you come?
Well, yeah.
Like acknowledging that historically the coastal margin was at Lambton Quay.
That's correct.
So, but on the assumption you're looking at what's there here and now, how much further inland than Jervois Quay do you come in your view?
Well, I wouldn't come back much further. And that's not to say, I mean, go back to the Boffa School report, which talks about the coastal marine area, the coastal environment area, which includes coastal marine, and then the coastal influence zone. And that for me is the significant bit. Just because you've stepped over a line, you've stepped over a road, you come to the other side, you're behind a building, doesn't mean you've lost the coast entirely. You're still in an area that's heavily influenced and heavily influences the coast. So that's why I tend to err more on the side of the coast. Is actually almost pretty much where you're right in, and you can feel it, you can see it. You know, the sea spray sitting in the face type of stuff. And coming further back than that, it's not.
Thank you for your assistance. Mr. Burge, any questions? Yes.
Just one from me. With regards the difference between your approach and Mr. Anstey's approach, which is obviously the broader picture versus you narrowing it down, being more defined in your assessment, and just hearing you say it's difficult in the, you know, in the coastal environment, for example, just down the road. Would, in your view, it be better generally to be more defined and more drilled down and less broad? Or are there certain circumstances where this is of greater advantage rather than just saying they're looking at the bigger picture?
Yeah, well, actually, I can agree with Mr. Anstey's answer on this, which is, wouldn't it be lovely if we could do that? Wouldn't it be great if we could get down to that detail? And there are situations when I've been involved in plans where we have walked a coastal line to map it really clearly. But the coastline around Wellington is immense, and it's just not practical to do that. You know, we don't want the resources, we haven't got the time, and so what's the best next method to do that? Well, map it broadly, and then let submitters go, well, are you sure about that? And then investigate those areas, because that's obviously where it's a bit more challenging.
But that's then on the submitters.
It is
to actually do that and go through the process.
It is, and that's a problem.
Yeah.
But it's, I guess I'm putting an olive leaf to the council and saying, look, I totally understand the situation, and it's not possible to go to the level of detail that we have across the entire city. It's too hard.
Yeah, great. Thanks very much for that.
I think that's us, Mr. Bray. We'll turn to Ms. Whitney.
Thank you.
Thank you. So I've just got 2.5 pages, if you'll permit me to go through. And again, I'll send them in, because a couple, 1.5 of those pages is particular comments on particular provisions, policies and rules. Just some detail, so I can provide them to the panel. So really there were just 3 outstanding issues in my evidence. So I've obviously read all the supplementary evidence and listened to the questioning, and I can confirm my position on these 3 points is the first one's relation to special amenity landscapes. So I support the supplementary recommendation of the officer for the insertion of characteristics within Schedule 11, just to confirm. And I also accept the supplementary recommendation to not provide reference to the quarry within the Horokiwi Stream Valley SAL. So that's no longer outstanding from my perspective. The second issue is in relation to hilltops and ridgelines. So I still continue to have concerns about the appropriateness of the overlay, and I would support their removal, but I am pragmatic and realistic that that's not going to happen. So my position now is that, you know, should it be retained, it just needs to recognise activities such as the quarry, which are within the overlay, and that the provisions are appropriate. In terms of NFL 03, which is the objective for hilltops and ridgelines, I guess my position is I remain supportive of the retention of the objective as notified. And I guess my main issue is with the term open space, that it's not present in all cases, i.e. the quarry has an overlay over it. And I'll just carry on, and maybe then we can discuss the actual provisions in detail. And obviously the third issue is relation to the coastal environment line, and that's been well canvassed, and my position still stands in terms of supporting the overlay adjustment as outlined in the evidence of Mr. Bray. So as the panel will be aware, the coastal environment line has implications for the rule and policy framework, both within the district plan and then outside in terms of calling into play the NZCPS and the natural resources plan as well in terms of rules triggered under that. So it has a lot of wider implications. Just in terms of the precedent issue that's been raised, I agree with the comments of Mr. Bray. In terms of the planning framework, the opportunity to amend the coastal environment line is really confined to the submission and hearing process. And once decisions are made and the plan's operative, the line is in effect locked in, subject to any future plan changes. Obviously, any party can apply for resource consent to undertake activities, but not to amend the line as it relates to their site. So in my opinion, the perceived issue of precedence is not a reason to ignore the merits, reasoning and methodology of the Horokiwi relief sought. So just, I am conscious that the panel have quite a lot of lines shown in relation to the Horokiwi site. So I did provide a link to a web viewer in my evidence, which I hope worked. And I just have updated as well that to show the line, the potential rezoning line that was addressed at Hearing Stream 6. Just to provide another context for the panel, and that follows the line identified in Hannah's evidence as well, supplementary. So
let's clarify. So if we clicked on that link again, that
line will show up in blue.
Okay.
It's labelled.
Yes, so the link has been changed.
The link, no, the link is still works. It's just
been
updated
to a new.
format.
Yeah,
So,
no, that's fine.
and I provided the link as well in my latest speaking notes, so you can click on that as well. But it's the same link. And obviously we're happy to put any other information on there that would assist the panel. I have provided as well, just for the ease of the panel, which I will submit just in a screenshot as well, attached to my speaking notes.
Yep.
So in terms of specific provisions, if I can just comment on NFL P2, CE P10, and then two of the rules, NFL R2 and R10, just very briefly. So NFL P2. So I acknowledge P7 specific to quarry operation in terms of hilltops and ridgelines. This is the policies for hilltops and ridgelines. P2 is use and development within hilltops, ridgelines and hilltops. And I've listened to the questioning by the panel on that policy to the experts. And the latest thinking I heard, and I appreciate things may have moved on, was an idea from the panel that the policy be framed along the lines, and I think it was Commissioner Daish that recommended this, and I provided writing in my speaking notes. Essentially, I support it, and the approach was enable use and development with identified ridgelines and hilltops where the activity is compliant with the underlying zone provisions, or there's a functional operational need to locate within the ridgeline and hilltop area, and in either case of one or two, any adverse effects on the visual amenity and landscape values can be mitigated.
And your answer to the follow-up question I've been quizzing planners on is can be mitigated at adequate distance. Anything can be mitigated, and it's the appropriateness of or the extent of mitigation which is always the issue.
Yeah, correct. But I think that policy is sufficiently broad, and it does relate to any adverse effects as well. So I think there's quite a lot of scope in there for assessment.
Next provision.
Next one is just policy CEP10, which is for the coastal environment, the avoid policy. It's inappropriate activities within the coastal environment. So I'm aware the council rebuttal evidence at paragraph 42 recommended amendment to that policy to list specific activities to be avoided, and that reflects the Rule 11, which is the new quarrying, plantation and mining activities. I understand there wasn't specific drafting provided, so I just want to clarify that it be made clear that its references to new. Yeah, not just because I think avoid the establishment of quarry, mining or plantation could be effectively an extension as well. So I just think it has to be avoid the establishment of new quarry. So I've outlined that in my speaking notes clearly. And again, that just gives effect to the Rule 11, which refers to new. I just wanted to make sure that didn't get missed.
Okay. Of course, if we agree with your argument on where the CE line is, you might be somewhat more relaxed as to what P10 says.
Agree. But I think we'll keep everything.
But you want to keep all the balls in the air at this
Yes.
point. I can understand that.
And I think it would help other plan users as well. So to make it clear for the future interpretation and application of the plan. And then the other one is just the other two, the rules really, which is the NFL Rule 2 and Rule 10.
Just a minute, I'll just pull up the latest copy
So I'll
that
let
we
you
have.
pull up those.
NFL
Rule 10, Rule 2 and 10, and this relates to hilltops and ridgelines.
Yes.
So I understand when appearing before the panel on the 30th of April, the reporting officer provided some potential further amendments.
Correct.
And I think these were online at that night, shown in purple, if I'm correct.
Correct.
I think I've got the latest version. I guess my concerns with the changes, which I just wish to highlight and note, as I understand it, it appears the intent is to confine the permitted rule to certain zones. I'm just concerned how it relates to zones such as the quarry zone. There are some activities which are permitted within the quarry zone. For example, new buildings and structures in certain circumstances, and kind of by restricting the first part of those rules to natural open space or general rural zone or large lot residential, you're taking away that permitted pathway for quarry activities because you automatically default to the RD, as I read it.
It does reference all zones, doesn't it?
It does, but then you're only permitted where you're in a general rural zone, this is R2, or large lot residential, or any activity in the natural open space, and then if it does apply to all zones, why are those two clauses A and B needed? And I'm afraid I didn't have it in front of me when I was listening to the questioning of the officer, so I couldn't quite follow it, but sometimes it does help when you read it fresh too and try to apply it from a perspective of someone who hasn't had knowledge of how the rule was developed. So I guess just how I appreciate the majority of the hilltops and ridgelines overlay applies to open space and rural zones. When from my look, there was some maybe future urban, maybe, and the quarry was kind of an anomaly in terms of an existing activity which has got the overlay on it.
Okay, thank you.
And then I guess my other concern, just in terms of Rule 10, was the matters of discretion. I guess I had concerns with the avoid directive within that matter of discretion. I don't think it lines up with necessarily the policy. Particularly given, to my mind, hilltops and ridgelines are a lower level tier in terms of landscape visual areas to be protected in the plan. So I have concerns with that void directive. It infers quite a high bar, and then just some of the subjective wording, such as visually obtrusive and what is an upper slope and things like that. So those were just my outstanding concerns. Otherwise, I'm comfortable with the rules and policies.
Thank you. Just a query on the last one. What is your issue with the test of visual obtrusiveness?
Well, I guess one of the issues as well that the values in those areas aren't, there's no information about what you're trying to protect.
Does a test of, maybe I should ask Mr. Bray this question, does a test of visual obtrusiveness depend on what the values are or what there is currently there? Or just does it not?
I can jump in as well. Isn't it also a question of perception and subjectiveness? What someone finds visually obtrusive.
We'll ask Mr. Bray. Is that something on which landscape architects would opine?
Yeah, we would say that you definitely need to understand the values that you're trying to protect, and possibly, if it's relevant, from where. You know, anything can be visually obtrusive, depending on the scale of it next to where you're standing or where you're looking at it from, how far away from it you are. So, what is it that you're concerned about, that obtrusiveness?
Like if you're standing 3 feet away, it's going to be pretty obtrusive.
Exactly. But if
you're 3 kilometers away,
it could still be.
It could still be.
You know, 200-meter turbine could still be visually obtrusive if it was in a particular location on a particular ridge that was, you know, of particular value. Or it might not be if those values weren't identified and actually, you know, there were other things that were more important. If it helps, one of the things I do a lot of work with is with cell phone towers, which I think most people in the world would rather not have them. And engineers always talk about a cell phone tower needs to be in line of sight of the receptors. And so I've had lots of discussions with panel members on, well, does that make it obtrusive? Well, actually, it's remarkable how you do not see cell phone towers. They're not actually visually intrusive most of the time. Sometimes they are. So it is totally about the context. So the more information you can give about the context and what it is that matters in that context, the better you can make decisions.
Okay, Ms. Whitney, I only had one additional question for you. And I think that Right. Well, have answered this, addressed this question in stream 6, but I've forgotten what you said there. To save me going back and rereading it again, what difference does the CE line make in practice to the operation of the rules as they relate to the quarry site? What is the significance of being one side of that line from being on the other?
I do not have the activity status come to mind, but in terms of at a general level, it calls in generally a stricter policy approach, particularly where you've got NZCPS values such as significant natural areas. Comes into play for those, and you have more void policies, and obviously with the SAL special amenity landscapes as well, which covers part of the site and is within the coastal environment. Obviously a void for memory significant adverse effects on those values as well. So it definitely introduces another level of policies and rules. I can't bring, sorry, I don't have to mind the activity status. I think I provided my
some
evidence.
vague recollection that there's some combination of the CE and SNA provisions.
There is SNA, yes, correct. That is a key one as well. But obviously, and I haven't really addressed that in depth in my evidence, given SNAs are going to be addressed later, as I understand. I did provide a summary table, the activity status within my evidence on page 30. And that outlines the various policies where you're inside and outside the coastal environment. And obviously, I'll let you get to the page.
Yeah, got it.
Page 30. And obviously, for an example, SAL inside the coastal environment, it now is recommended by the officers to start off with the word avoid. So there is a higher bar, whereas outside you have more, it's a bit of the wordings only allow. So it went from provide for to only allow, and then inside the coastal environment's gone from provide for to allow. So there's a lot more of a directive avoid policy approach.
Okay. Mr. Dash, any questions for Ms. Whitney?
Yeah, just a couple. NFL, Rule 10. You made that, we had that discussion, and Ms. Van Haren Giles had produced an amendment. We had evidence from Parkvale yesterday on that rule as well. And I've got the two things which were problematical to them were in the new number 2, was the word avoid being visually obtrusive, and we've had that discussion. But also the other thing which was of concern in terms of the new A underneath 2, ensuring visual continuity is achieved on the upper slopes up to the apex of the ridgeline or hilltop. I think we know what the apex is, I mean the top of it, but you know, do you think that upper slopes terminology there actually provides sufficient certainty to know whether or not that matter of discretion is relevant or not? Is it easy to deal with from a planning perspective in terms of that rule?
I briefly just mentioned upper slopes earlier, but I didn't expand on it. Yeah, agree. I think it's problematic, particularly given the hilltops and ridgelines are kind of almost the upper slopes, as I understand. Again, within context of there's minimal information provided in the plan about what the values are and things like that. So when I, as a planner, and obviously landscape architects may have different opinions, but when I read this,
I think you can almost rely on them for that fact.
yeah, I think so. On the upper slopes, it's so open as to what that is.
So
Is it the upper slope as a whole,
would it assist in terms of planning interpretation if it was the defined upper slopes as mapped?
I think it's going to be so
The defined slopes.
Would it be contextual as well? And is it the upper slopes of the actual whole hill, or is it just within the upper slopes of that hilltop and ridgeline?
Okay,
So,
well, I think Ms. Van Haren Giles was going to be looking at that anyway, in terms of her right of reply. The other one goes back to your evidence to chief and your paragraph 5.2. So set many of the officer's recommendations on the above. Where main point relates to the outstanding location of the coastal environment. So the actual written words themselves, other than those which you've outlined that you've still got an issue with, you're generally, the package, you're generally happy with where they've landed. In terms of NFL, you know, you've said there's some exceptions to those.
Yeah.
But the others you can live with.
generally, yes. Just NFL 03 though, that objective, I prefer that as notified. That's the hilltops and ridgelines
Yeah.
objective. So, yeah.
On that score, discussing that with Giles, asking whether reference to continuity of open space should talk about relative continuity, given that Meridian have stuck a number of large towers at regular intervals along some of those ridge lines. What's your view? Is because the point has been made that the landscape architect thinking underlying that emphasised the continuity of the ridge lines that had been identified and as being an important element, so which is obviously where that addition has come from. But the question is, does that need to be qualified in terms of relative continuity? Because clearly, I wasn't thinking of the quarry in that, so I was thinking of the wind turbines, but they're not very open or not very continuous, in the sense of they interrupt the continuity. So what's your view? If some reference were made to continuity, does it need to be qualified, and if so, how?
Agree. I mean, I guess my point would be, my preference would be to remove that wording. But
Yeah,
if it is to be, but if it is to be retained, then definitely a qualifier. Thinking it's relative to the right word, it probably relative to what? Yeah.
Or generally continuous?
As Mr. Bray said, it comes back to the values as well, which you're trying to.
You did suggest spaces, didn't you?
I did, yeah, but I still don't, I think that reflecting on that, I don't think it addresses the issue, yeah. And I think I said my preference was to remove that word, yeah.
I think having read the ISMIS report, that is the genesis of how the ridgelines and hilltops overlay is now being pitched. Continuity is a relevant value.
Yeah.
That gave rise to this, and so if that value is going to be recognised, how should it be recognised?
But with all due respect, when I read that report as well, there were, in terms of the Horokiwi example, there were no references at all to the existing quarry. You know, so no recognition of some of those activities within those hilltops and ridgelines. I guess I'm just concerned with the blanket policy directive applying.
Well, like I understand the point, and hence I was asking whether there is a need to qualify it.
Agree, yeah.
But if, to the extent that it is provided, continuity is a relevant value, how do you describe it? Is you say, as you say, saying relatively continuous invites the question relative to what? Is it generally continuous?
Well, I admit as well, I haven't read the original plan change for those hilltops and ridgelines. And I'm not sure when people come to apply this, whether they would as well, or have, or do. I didn't read some commentary about there was variation between, in the ISMIS report about the officers in terms of how they formed or understood. I guess it just comes down to the lack of identification of the values and what actually you're wanting to protect through those hilltops and ridgelines as well. And I guess that comes to my fundamental concern with how they're framed in the plan.
Any other questions? Me? I think that's us. Thank you very much to the Horokiwi Quarry team. Sorry, didn't get your chance to shine, Mr. Baker, but these things happen.
I'm happy to sit with it up to speed with some of what I just it's right over my head.
Turning this, you are the last submitter, so just have a brief discussion with the reporting officers. As previously, we're going to go into a huddle and think about things we would be particularly assisted by your input on and reply. Don't imagine anything will come as a surprise, but I'll endeavour to put that on paper as soon as I can. I haven't looked up, but I'm assuming that you are comfortable with whatever the reply date is that's previously been fixed, as I can't remember what it is.
To what that date might be.
Oh, well, you're obviously very comfortable if it's not burning brightly on your diary. Then we will proceed on that basis, that we will hear from you in reply. We'll hear, there are some things that I've given leave, but I think we'll have everything in the kitty by the end of next week. So that will hopefully not stress you. Is there anything you think? Yes. Is there anything you need us to address that you've identified? On that basis, we will adjourn stream 8 on the basis that a different team, but including myself, will be back for stream 9 in June. Thank you all.